The key development in what might be the largest and soonest threat to Donald Trump's actual liberty, the Jack Smith coup trial. Because Jack Smith, in that case, has a new filing asking the judge for a narrow order on what Donald Trump, as a defendant, is allowed to say. And it's quite interesting because it cites the threats that he's already made and things he's said that have been interpreted as threats against witnesses, other individuals involved, and even law enforcement. The repeated inflammatory public statements, Smith writes, are likely to materially prejudice the jury pool, create fear among potential jurors, and result in threats or harassment. The order would simply seek the judge barring Trump from public statements about potential witnesses' identity, testimony, or credibility, and bar him from making disparaging or intimidating statements about any party, witness, attorney, court personnel, or potential jurors. Those are the words of the filing by Jack Smith's office. Whether the judge uses some, all, or none of those words in any potential order is the big question. Smith emphasizes that this is a narrow and well-defined request, but arguing that it's necessary with Donald Trump as a defendant already creating substantial danger of materially prejudicing the case. This is the big question facing now this case and the judge, and I want to get right to it with Andrew Weissmann, a former Mueller special counsel, former general counsel of the FBI, and a former federal prosecutor. Andrew, I mentioned we have a lot coming up, and you're going to be a part of some of that. But this now is hanging over everything. People are wondering, what does an order like this mean, and what might the judge do?
Yeah, so we don't know yet how the judge is going to rule on it, but it is a very interesting filing. I think for many people, including myself, it is something that we've been wondering why it wasn't done earlier. There is a lot of precedent for this. As you remember, early on in the New York civil case with respect to E. Jean Carroll, the federal judge took steps to protect the identities of jurors because of the concern about what Donald Trump would do in that civil case. Well, since that time, there have been threats in the Manhattan Alvin Bragg case to the prosecutors, to the judge, to their families. And as the filing today says, all of that has continued, whether it's respect to Georgia, whether it's respect to Florida, and obviously with respect to D.C. also. And the precedent areas, you know, in D.C., which is cited by the prosecutors, is the Roger Stone case, where the threats included posting a picture of the very eminent federal judge and having crosshairs next to her face. Very similar to what we saw with respect to a bat that the former president had with respect to Alvin Bragg. And so what they're seeking is limited restrictions that, by the way, apply to all of the lawyers in the case. And they make that point. They say the lawyers are bound by this. They pointedly say that Donald Trump's lawyer, John Lauro, has violated the local rules on that by making these public statements, and says that Donald Trump should not be able to do what his lawyers can't do and should not be making these statements. And obviously, this has to be taken very seriously by Judge Chutkan because you don't want to see violence erupt. And there obviously is a pattern of actual violence, not just the threats of violence.